So I think it's time to go ahead and get started for today's Wallace Stegner Center Greenbag presentation. I'm Bob Kiter, Director of the Wallace Stegner Center for Land Resources and Environment here at the University of Utah, S.J. Quinney College of Law. We're very pleased to welcome you to this presentation during the second semester. Let me begin with our acknowledgement of our native land presence here at the university. We acknowledge that this land, which is named for the Ute tribe, is a traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we reaffirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. Let me move forward by noting a couple of upcoming Stegner Center programs. Toward the end of the spring semester, on Thursday, April 14th, the Stegner Center will host former Salt Lake City Mayor Ralph Becker, who's currently the Executive Director of the Central Wasatch Commission, who will be speaking on the ongoing challenges confronting the Central Wasatch Mountain Range. Closer in time, on March 17th and 18th, as many of you I suspect are aware, the Wallace Stegner Center hosts its 27th annual symposium on the Colorado River Compact, Navigating the Future. The symposium is held in conjunction with the Colorado River Compact's 2022 centennial. The symposium is sponsored both by the Stegner Center this year as well as the Water and Tribes Initiative. Will reflect on the past century of water management in the basin and envision our common future with respect to Colorado River waters, including strategies to share water, engage tribes, integrate environmental considerations, and adapt to climate change. Additional information, including the agenda and speaker list, is online on the Stegner Center calendar of events. I should note that registration for the symposium is now open with options to attend both virtually and in person. Early registration with reduced rate will end on March 4th. We hope that you'll join us. We think it's quite a lineup of speakers and a very timely program this year. Today, I'm very pleased to introduce Professor Richard Lazarus, who's the Howard J. and Katherine W. Aibel Professor of Law at Harvard Law School, where he teaches environmental law, natural resources law, Supreme Court advocacy, and torts. Professor Lazarus has represented the United States, state and local governments, and environmental groups in the United States Supreme Court in more than 40 different cases, and has presented oral argument in 14 of those cases. Most recently, prevailing on behalf of the respondent in St. Croix County in Murr versus Wisconsin, a 2017 decision of the court giving a federal cast to the concept of property, I might add. Before joining Harvard's law faculty, Richard was the Justice William J. Brennan Professor of Law at Georgetown University, where he founded Georgetown's Supreme Court Institute and also served as its faculty director. He writes broadly on topics relating to environmental law as well as Supreme Court decision making. His books include The Making of Environmental Law, published by the University of Chicago Press, and his most recent book is the topic of his talk today, The Rule of Five, Making Climate History at the Supreme Court, published a couple of years ago by Harvard University Press, which relates the inside story of the Supreme Court's 2007 decision in Massachusetts versus the Environmental Protection Agency, probably the court's most famous environmental law case. Professor Lazarus graduated from Harvard Law School in 1979, and he also holds a bachelor's degree from the University of Illinois in both chemistry and economics. With that, let me turn the program over to Professor Richard Lazarus. We're very happy to have you with us today, Richard, and we very much look forward to getting the inside story.
Thanks,
take it away.
Thanks a lot. I'm really delighted to participate in this event, and particularly because it's hosted by not just Bob, but also by the Wallace Stegner Center, a real jewel at the University of Utah School of Law. This is a particularly fun time for me to do this because, as some of you know, I got to teach a class earlier this semester to a wonderful group of Utah law students on a related topic, that was environmental law in the Supreme Court. So what I'm going to talk about today is that book, as Bob said. It's called The Rule of Five, Making Climate History in the United States Supreme Court. I'm going to divide my talk into three parts, followed by, I hope, looking forward to some Q&A. First, the arc of the story, my overall goal in writing the book. Second, I want to highlight parts of the book's story, provide you all with a sense of the book's voice and what makes the story, I think, so engaging. Then third, I want to describe to you an unanticipated challenge I had in writing the book, and then how I chose to address it. So first, the story's arc, and my primary objective in writing it. So the book is divided into 20 chapters, followed by an epilogue. The arc really begins with a guy named Joe, and the story ends with a Supreme Court ruling that made history. The most important environmental law case ever decided by the United States Supreme Court. That's Massachusetts versus EPA, often referred to as environmental law's own Brown v. Board of Education. A terrific and a very important case, which has had not only major impact on climate law in the United States, but really worldwide impact beyond. Now, my primary objectives in writing the book were twofold. First, I want to write a book for a popular audience. My other books have not been for popular audience. This is for lawyers and Supreme Court advocates, but really also not just for academics, for people just interested in the court and climate change. I wanted to write a book for that audience to reveal what makes Supreme Court advocacy so challenging, what makes it so fascinating, and from both sides of the lectern, where the advocate stands before the justices on one side of the lectern, then the other side, within the court itself. I want to open a window for the general public to see inside. The extraordinary amount of strategy, maneuvering, conflict, the personal and professional drama, not from bad motives, but just because the stakes for the United States Supreme Court are so extraordinarily high. I also want to write a book for a general audience to reveal what has made it so difficult for our country to address climate change, why it's proven so hard, often for reasons that most people don't know, and why, for that same reason, this case was so important. There's no more important environmental issue facing the United States or the world these days. Coronavirus underscores there's no escaping the need for global cooperation when you have this kind of global threat. And this is certainly a day where we're seeing about the different kinds of global threats can occur in terms of instability abroad. I began researching the book in 2015, 2016. I wrote it mostly in 2018, 2019, a little bit of 2020. And I approached the research the way I would a Supreme Court brief. Absolutely scorched earth. Interviewed everybody. The Clinton administration officials, the Bush administration officials, lawyers from both sides. I interviewed judges, and I interviewed the justices. I also sought all the underlying documents. I ended up knowing far more about this case than any of the participants did. I think they were not that happy that I got all the documents that I did. Those were public record documents, of course, after a lot of requests, but also voluntary documents. People just gave them to me without other people knowing they would. I got boxes and boxes and boxes. I got jump drives and jump drives and jump drives. So I had pretty much a sense of everything in the case. So what's the opening scene in the book? Chapter 1, October 1999. So this is 8 years before the ruling. After a year delay, Joe Mendelson, you picture here, walked from his Capitol office down to EPA, and he hand delivers a petition. A petition which demanded that EPA regulate greenhouse gas emissions from new motor vehicles. At this point, you have to understand, EPA had done no regulation of any greenhouse gas emissions at all under the Clean Air Act. And Joe was fed up. He was fed up by the lack of action of the Clinton administration, which he expected would do something with Al Gore, after all, as the vice president. And they just weren't. So who was Joe Mendelson? He was a young public interest lawyer who worked for a public interest organization no one, and I mean no one, had ever heard of. The Center for Technology Assessment. How many employees? 5 employees. A few part-time, a few full-time. They were paycheck to paycheck and quite often for no paycheck at all. They had small offices on Capitol Hill, and they actually had been evicted from those offices just before Joe filed his petition because they violated the local zoning ordinance for having an organization, what was really a little residential building. Joe worked very much alone. He worked on that petition late at night by his daughter's crib. None of the powerful national environmental groups like NRDC, Sierra Club, Earth Justice supported his efforts. They didn't want him to rock the boat. They didn't want him to challenge the Clinton administration. And they actually actively opposed him. They even tried at one point to cut off his funding. And he only had one funder. But Joe refused to bend. He filed a petition demanding the EPA act. His feeling was, these national groups are not my bosses. I don't have their fancy offices and the rest. I don't have their resources. They can't tell me what to do. I'm in the business here of pushing. I'm an activist. It took me a year to decide to file after he drafted that original petition in 98. He took it out of a desk drawer in 99, October. He finally pulled the trigger. That October day, he walked down to EPA himself. He hand filed it at the agency. Joe's petition made a simple argument, and that was greenhouse gases were clearly air pollutants within the meaning of the Clean Air Act. They endanger public health and welfare, and their emissions included from new motor vehicles. Therefore, EPA had a duty under the statute to regulate them. The petition made its way to the docket room at EPA, where it was formally received by the docket clerk named Jamie Poole. She stamped it, she signed it, she put it in a cart leading to the general counsel's office at EPA. No one then imagined that 7 years later, that petition would end up in the United States Supreme Court. It just wasn't even on anyone's radar screen that would happen. All right, so what happened when it gets there? It finds its way into the courts eventually, but there was nothing easy or smooth about that path to the court. It had started at the agency. And at first, actually, there was reason to think that Joe's petition might be granted, not denied, but not by the Clinton administration. They sat on it and ignored it, but by the Bush administration. Because it was President Bush as a candidate in the September 2000 with Bush, who actually campaigned making a pledge that he would regulate greenhouse gas emissions under the Clean Air Act. And he appointed to his cabinet people determined to do just that. He named head of EPA, Christine Todd Whitman, who Bob would know. Christine Todd Whitman was governor of New Jersey. She was a person of national stature. She was well known, a very popular person, and considered presidential timber in her own right. And she took the job at EPA because of climate change and greenhouse gases. New Jersey regulated them. She interviewed for the job. She told Bush that's what she wanted to do. She took the job because of Bush's campaign pledge. And she was determined to do it. And as soon as she became EPA administrator in January 2009, one of the first things to do was fly to Europe to engage in negotiations and discussions with other countries on climate change. Colin Powell was Secretary of State. He was a climate hawk. Within a week of the inauguration, January 2001, Powell asked for a briefing on climate change. Why? He thought it was an enormous threat to international stability and national security for that reason. Condoleezza Rice was National Security Advisor. She was no less a climate hawk. feeling it was very important to safeguard the national security that we actually deal with domestic greenhouse gas emissions. But no one was as much committed to this issue as the person you see in the lower right. That's Paul O'Neill, Secretary of Treasury, who came from being president of Alcoa. O'Neill, when he interviewed with Bush, he raised the climate issue. He raised it during his confirmation hearings. And he felt so strongly about it that before the very first cabinet meeting in January 2001, he went to the White House early. He went to the cabinet room where they're all going to meet, and he placed in front of everybody's chair, on the table in front of everyone's chair before they got there, a copy of a speech he'd given a few years earlier, where he compared the threat of climate change to the threat of nuclear holocaust. That's how he felt. Each of them was committed, they were working together, and they all got outmaneuvered. They got kneecapped by this guy, Dick Cheney. Behind their backs, without any consultation with any of them, Dick Cheney met with President Bush and persuaded Bush to renege on his campaign promise. That was just a few weeks after the inauguration. And Bush did it without talking to Whitman, EPA, without talking to Powell, Rice, or O'Neill. When they heard that Cheney was trying, they raced to the White House, literally raced to the White House to try to stop Cheney. They got there too late. When Whitman walked into the White House to meet with the President Novoff, he said, "Christie, I've signed the letter." What did the letter say? The letter back to Congress said, "I'm not going to regulate greenhouse gases. And more than that, in answer to the legal question, I do not have a legal authority under the Clean Air Act because greenhouse gases are not air pollutants." And EPA accordingly denied Joe's petition. At that point, we had the case. By the time Joe's case reached the court, however, he was no longer alone the way he was at the beginning. Hundreds of lawyers were on his side. About a dozen states, more than 24 of the nation's leading environmental organizations. And they called themselves the carbon dioxide warriors. But when they lost that first round in courts, all but one of them thought they should end the case. Only one out of the hundreds of lawyers thought further review was warranted, including the possibility of Supreme Court review. That lawyer was this guy, Jim Milkey, from the Massachusetts Attorney General's office, a career lawyer there. Jim, unlike everyone else, said we should roll the dice. We shouldn't acquiesce in the loss. We should take this and seek further review. All others thought this was a terrible idea. Why? Because they could lose more. They could lose big. They could lose big with the DC Circuit en banc. They could lose big in the United States Supreme Court. They put enormous pressure on him. Don't do this, Jim. Don't file a petition. Wait till another case in a better time for us to press these issues. They literally called Jim's boss, the Massachusetts Attorney General, to tell him what a terrible idea it was. They called Jim up and they said, "The future of the environmental movement is on your head if you file this petition." What did Jim do? He filed. What did they do? They joined the petition. Why? Not because they thought it was a good idea. They wanted to control its language, and they didn't think there was a bad chance this case would ever be granted. But then, another shocker. The court granted review on June 26, 2006. Lawyers out there recognized a lot of interesting cases were granted that day. But the most amazing grant was Massachusetts versus EPA. Why? It was the first time in more than 30 years, the Supreme Court had granted review at the request of environmentalists over the opposition of the federal government. The last time they had done that was the early 1970s, a case called Sierra Club v. Morton. But in that case, they had done it, and then the environmentalists had lost. But in the midst of the celebration of the environmentalists and everyone who was shocked the court granted review. It was also sobering when they thought about it. Why was it sobering? It was sobering because they knew how many votes does it take to get Supreme Court review, and how many votes does it take to get a win in the Supreme Court, and it's not the same at all. So they had to worry basically about whether they could get 5 votes. 4 votes to grant cert, but 5 votes to get Supreme Court review. The book now pivots. I'm going to take you to chapter 12. That's the lure of the lectern. It concerns the battle for who should present oral argument for the United States Supreme Court. Everyone agreed, of the 100 lawyers or more on petitioner's side, that the best lawyer should present argument. That was easy. But as you might guess, for those of you who are law students or lawyers, those lawyers did not agree about who that should be. And ultimately, the states favored one person and the environmental groups favored another. It was a good faith disagreement. There were 2 strong candidates for the position. And it's not that unusual to have that kind of conflict. In the lower courts, it's resolved by having more than one advocate. But the Supreme Court, in a case like this one advocate, only one advocate. And I've seen those battles get worked out even by a coin flip at the end because they can't agree. The stakes and emotions run high, as do competing egos and ambitions. In this instance, the oral argument conflict was as destructive as I've ever seen one ever have. I've seen lots of fights of oral argument. I've never seen one so intense. In fact, so intense that 15 years later, the lawyers involved on each side of that debate are still not speaking. And they were good friends. And they won the case. Even after it was seemingly settled that Jim Milkey would do it. They settled that in early October, about 7 weeks before the argument. And Jim Milkey did moot court after moot court and was intensely preparing for it. Only days before the argument, the environmental groups attempted a coup to knock Jim out of the argument, to replace him with their preferred attorney. They called him at home on a Saturday morning, not long before the argument, and said, Jim, you're not up to this. You're not good enough. You need to step aside. I can tell you, that is a truly crazy idea. You can see how Milkeys responded. That's not going to happen. You don't bring in a new lawyer in a Supreme Court case a few days before and say, this one will argue rather than that one. It's a crazy idea. But the craziness of it underscores, really, the depth of distrust on the petitioner's team here, which was profound. The next several chapters describe the oral argument. They're designed to give the reader the sense of the stunning physical setting of the courtroom, the extraordinary give and take between the justice and the advocates, but also between the justices themselves. The oral argument for the court is the first time the justices each learn what the others think. They have a tradition, a norm in the court of not talking about the merits beforehand. So they come to the argument, that's when they learn what their colleagues think. And the argument of 1 hour is the longest time the justices will ever likely discuss the case together. When they meet a couple of days later at conference to vote, they don't deliberate at length and then vote. Actually, they vote in order of seniority. And that happens in the beginning of it. One at a time announces their reason and their vote without listening necessarily anybody else and what they think. And they don't take an hour to do it. So the oral argument is a time when the justices are really having their first conference together to learn what each other thinks through the questions that they ask. And they often answer the other's questions through the advocate. The opportunity of the oral advocate is, unbelievable. They get to be there as a principal player when the justices are first discussing the case among themselves. And the bench is about, you can see from the chapter, 74 inches from where the advocate stands. It's an extraordinary combination of the most formal, intimidating room you've ever argued or seen yourself in with this real intimacy. You're much closer to the justices than you are in a normal courtroom. It's so close, the advocate can actually reach over with their hand and put it all the way out. The chief can do the same, and they can touch fingers. And the bench itself is not straight across. It wraps around. So you can see the justices, to some extent, on either side of you. The advocate's challenge is this. 1, decide how to frame the issues in the way most likely to win. Supreme Court advocacy, like most advocacy, is all about framing. How you want the justice to think about your case. What do they care about? What's the way to frame it? Have them vote the way that you want. It can make a huge difference. You frame it one way, you might lose. Think another way to frame it with these justices, you might win. Or no less importantly, have a soft landing, not an important loss. You also have to anticipate all the hard questions and develop crisp answers. No one thinks on their feet who's a good Supreme Court advocate. You've thought of all the questions ahead of time. And you've come up with answers, yes or no, reason, and then transition back to your theme, to your argument. Yes, no, reason, theme, transition. Yes, no, reason, theme. 10 to 15 seconds. Why? The norm is to answer about 50 to 75 questions in 30 minutes. So you better be quick and on point. If not, they're going to ask you another question before you had a chance to answer it. And the justices' questions are the lawyer's equivalent of trying to hit a Major League Baseball pitch. You may think differently of different justices based on your perception of ideology, but here's what they all are. They're really smart lawyers. And they ask really good questions. And you hear an oral argument about 60 to 65 cases a year. They're all in at that argument. They know everything about that case. And don't fool yourself to think any differently than that, because they are pretty amazing. So as a treat, here's what we're going to do. I'm going to play you some snippets from the oral argument in the Massachusetts EPA case. We're going to start with Jim Milkeys' beginning, which I want to discuss with you. So here's the beginning. Listen in.
Mr. Milkey. Mr. Chief Justice, and may it please the Court, if I may, I'd like to frame the merits very quickly and then turn immediately to standing. Although the case before you arises in an important policy area, it turns on ordinary principles of statutory interpretation and administrative law. EPA made a decision based on 2 grounds, both of which constitute plain errors of law reviewable under any standard. It's not asking the Court to pass judgment on the science of climate change or to order EPA to set emission standards. We simply want EPA to revisit the rulemaking petition based on permissible considerations.
All right, now imagine you are one of the climate activists who slept on the cold DC sidewalk in late November 2006 to hear the case of the century, the first climate change case in the United States Supreme Court. And your advocate, your champion, is going to be before the justices and tell them about the catastrophic threats presented by climate change and how outrageous it is the federal government's not doing anything, and how it's incumbent upon the court to order the federal government to address this problem before it's too late, all of which is true. And instead, your lawyer stands up there and says almost nothing about climate change. They say, well, yeah, it does arise in an important policy area, climate change. But this is just a question about ordinary principle of administrative law. And we're not asking the court to order EPA to do anything or to pass judgment on climate change. All we're asking for, look at it. All we're asking for is for EPA to visit the rulemaking petition based upon permissible considerations. Right? You'd be outraged. What are they doing? Why is he lowballing this case? Why is he saying this is ordinary principle of administrative law? This is not really a big deal or a big case. We're not asking you to order EPA to do anything. Just have them revisit the petition. Why? Because Milkey is a good lawyer and he wants to win the case. And he's framing the issue in the best way to win the case. It may make your heart go pitter-patter to talk about climate change. It may make my heart to go pitter-patter to talk about climate change. It doesn't make the hearts of the justices go pitter-patter. What makes their heart go pitter-patter? Administrative law. That's what they care about. That's what they think about. And Jim Milkey knows he's not giving a speech, right, running for office, campaign speech in front of people trying to get to vote for him. He's not in a congressional hearing talking about the threat of climate change. He's in front of 9 justices and he's got to get 5 of their votes. That's the rule of 5. He has to count to 5. So he has to think about the case the way they think about it. The best environmental lawyers are not necessarily the best environmentalists. They're the best lawyers. And Jim Milkey here and his team, who worked on this framing together, are being really good, smart lawyers. There's nothing happenstance about this introduction. They worked on this wording, on what was being said, whatever pauses were not happening, as much as you would in the beginning of a Broadway opening of a play, to figure out exactly how to pitch this case. So I'm now going to take you to a point in the argument when the Chief Justice identifies a major weakness in petitioner's side. The Chief is a really good lawyer. And the Chief knows they have a big weakness, the petitioners. And that weakness is this. There's absolutely nothing in the statute which required EPA to respond at all to Joe's petition to regulate. And in a background principle of administrative law, if there's not a deadline in the statute somewhere, and there are plenty of deadlines in the Clean Act for all kinds of things, all kinds of petitions, there's nothing for this one. Background principle of administrative law is agencies have a huge amount of discretion to decide when to decide something. And here, they had not decided greenhouse gases didn't change public health and welfare. They decided, 1, they had no authority, but 2, even if they had authority, they didn't want to do it right now. There are other things they wanted to do. And so the Chief says, what made an abuse of discretion for them to decide not to decide the issue and wait till later? Listen to the Chief's question, and then let's read Milkey's answer.
The first day this law is passed, there are a lot of air pollutants that come out of motor vehicles. I mean, is EPA immediately in violation of this statute if they don't issue emissions regulations for every one of those air pollutants on day one?
No.
And presumably the principle that they want to deal with what they regard as the more serious threats sooner. They want to deal with lead first, and then they want to deal with other stuff. I mean, when do they, I guess, move into an abuse of discretion and not exercising a judgment with respect to a particular pollutant?
The answer.
It's a great question. It's not obvious what the answer should be. I mean, you say, where are the statutes that say that they couldn't just decide not to decide this right now? Congress didn't cabin at all in the Clean Air Act, which they did for other kinds of judgments. So what makes an abuse of discretion for them to wait and decide it later? It's a tough question. Milkey knew this question was coming. Look at the answer. The answer, Your Honor, right, is when they don't rely on any of those grounds. They don't rely on information they don't have. They don't rely on background principle administrative law. They instead rely on the fact they don't like the Clean Act's regulatory scheme. Milkey's point is this. Yes, Your Honor, they could have decided not to decide this petition, to deny it now, but to say, we'll decide it some other time. For all kinds of legitimate reasons, and there's nothing we could have done about it. But the problem here is they chose an impermissible reason. They didn't choose one of the permissible ones they probably had. Like, we have to balance all kinds of things on our agenda. No court could have second-guessed that. Instead, they gave a wrong reason. It's a very narrow argument, but it's the best argument you can give. And you don't make up an argument and jump up and down. You give the best possible argument you can give as a lawyer and hope it flies. And then listen to see what happens next with Justice Ginsburg.
You were right, and then it went back, and the EPA then said, well, obvious reason also is constraint on our own resources. Suppose they said that. You said they didn't say it this time around, but how far do you get if all that's going to happen is it goes back and then EPA says, our resources are constrained and we're not going to spend them on this?
Your Honor.
Right? She says, is that all you're asking for? To go back to EPA and have them give the reason we know they can give? And that limited time, limited resources, we're picking things as we can do as a matter of discretion, background principle administrative law. What do you get from that? Is that all you're asking for? And Milkey's answer is, yeah, that's all we're asking for. Why? It's all they could ask for and have any hope of getting 5. You could ask for more, you're not going to get 5 votes for it. They're aware of the weakness of their case. They're aware of all they can possibly ask for to get a win. And they're going for the win. Because if the court decides they're right about this, then the court will have to answer the question whether greenhouse gases are air pollutants or not, which is really what they want to get, along with standing in the case. Now, the last chapters of the book shift the case from one side of the lectern to the other, from the side where the advocates argue to the other side, literally behind the massive red curtains behind the bench, where the justices and law clerks work in their chambers. Describe what happened at conference. This is the conference room. This is literally separated by a hallway from the courtroom. This is where the justices meet privately, in this case, 2 days after the argument. Argument was November 29th. They met here Friday morning, December 1st. When they meet at conference, no one is present in the room but the 9. They sit by seniority in a certain order, with the Chief Justice at one side, the next most senior justice, Justice Stevens, at the other, the next most senior, Scalia, Kennedy, Thomas, Souter, Ginsburg, Breyer, and those junior back then, Alito. Alito, you can see, is close to the door. That's because someone knocks on the door. It's his job as junior justice to answer the door. They go around in order to discuss the case. The chief summarizes the case and announces his vote before anyone else has talked. Goes to Stevens. He announces his vote and gives a few reasons. Then Scalia, then Kennedy, then Thomas, and so forth around. As soon as Kennedy voted, everyone knew the outcome, because Kennedy voted in favor of Massachusetts environmental groups petitioners. The case would be 5-4. And Justice John Paul Stevens would be the senior justice of the majority, which means he would have the power to decide who would write the opinion for the court. And that's really important, because the conference vote is just the opening bell. It's just a tentative vote. It's only when we have written opinions, which 5 justices then join, you have an opinion of the court. And justices frequently, it happens a lot, change their votes from conference to later on, especially when you have a 5-4. When you have a 5-4, believe me, those in the 4 are working their butts off to try to get that 5th vote to switch sides. And Justice Kennedy was known to be a justice who would switch sides. So Justice Stevens had a big decision to make, and I interviewed him at length in Florida about how he did decide to assign opinions and about the Massachusetts case. He wanted to assign Massachusetts to himself. Why? Big case. He liked to write big cases. Second, he believed strongly in the climate change issue. He was a lifelong Republican. Stevens told me he could not believe that his own party was not taking this issue seriously. He also wanted this opinion to be written to the American people. He said, sometimes I write opinions for the lawyers. Sometimes I write them for law students in casebooks. Sometimes I want to write them to the American people to make a broader statement. This one I want to write to the American people. But the problem was, he knew if he assigned it to himself, he might lose Kennedy's vote. And the best way to keep Kennedy's vote was to assign the opinion to Kennedy, a well-tried, successful strategy in the court. Assign it to the justice at the margin, because the odds of them switching the vote go away almost completely, because they'll write a way that they can sign on to. The problem is, if you assign it to Kennedy, it would be a narrow opinion. So Justice Stevens decided ultimately to assign it to himself, and it worked really hard to keep, or actually get, Kennedy's vote. The book tells the story of a Jedi master, a bow-tied octogenarian Jedi master, hard at work, trying to get Kennedy's vote in the case. He circulated his first draft of the opinion. How many votes did he get, including his own? 4. His second draft, 4. His third draft, 4. His fourth draft, 4. And the dissent, which is joined by 4, is circulated at the same time. Everyone trying to get Kennedy to join their side. Stevens starts to make some compromises to try to get Kennedy's vote. Changing this, washing away that, citing Kennedy over here, citing Kennedy over there. qualifying this, qualifying that to get his vote. Fifth draft, 4 votes. Sixth draft, 4 votes. Some of the compromises upset a little bit Justice Souter. And Justice Souter circulated a separate concurring opinion, which Justice Ginsburg joined, with really a more harsh attack on EPA. Seventh draft, 4 votes for Stevens. Eighth draft, bingo, 5 votes. And Souter withdrew his separate opinion, which no one knew existed until I found out about it in my research. And Stevens writes the majority opinion, and look at how it begins: climate change. It's not an ordinary principle of administrative law. He's talking about climate change first and last. The last chapter of the book shows how they really made history. How under the Obama administration, they took the EPA's loss in the Bush administration and they ran with it. All their signature climate change programs for reducing greenhouse gas emissions, the biggest ones, were all based on EPA's authority under the Clean Air Act established by Massachusetts versus EPA. And it was those efforts they made during the 8 years of administration that made the historic Paris Agreement possible. If it had not been for Mass versus EPA, that Paris Agreement never would necessarily have happened. So let me tell you about the unique challenge I had in writing this book, and that was the following. When I started writing the book, I thought I knew my ending. It would be Paris, of course. That's how it would end the book, how this case led to Paris. I didn't anticipate in 2015, when I started researching this, the results of the 2016 election. Maybe you all did, but I'll admit I was caught off guard. The question became what to do with it. And here's what I knew. I knew 3 things. One, I knew I had to acknowledge it to explain its relevance. But I also knew I did not want this book to become yet another Trump book, otherwise wed to the latest event of the moment. Why? Because my third goal was to have a story that was meaningful for a much longer time period. An inspiring story about what lawyers could do, and smart lawyers could do, and environmental people could do. And about Supreme Court advocacy and the challenges and drama of it. And about the importance of framing, the importance of thinking things through. I wanted a story that could be read and be meaningful for people decades from now, far past the presidency of Donald Trump. For years, readers who years from now could read and enjoy and learn from really a truly thrilling story. And perhaps so much in the future, someone might read it, this is my dream, might read it and say, who's that Donald Trump guy? So that's the role of the epilogue in the book, to place the Trump presidency in perspective, what lessons the book story has for all of us. And those lessons are several. One is, even the most significant Supreme Court case, like Massachusetts EPA or Brown v. Board of Education, alone does not transform the nation's laws. It takes far more than 5 votes of justices to do that. It can spark it. It can catalyze it, but it can't complete it. Brown v. Board of Education was decided, 1954? We're getting close to 70 years ago. And that decision hasn't eliminated racism in this country or segregated actions in the country. It took a lot of other things to change attitudes. It took Voting Rights Act. It took the Civil Rights Act, the Civil Rights Restoration Act. So a Supreme Court decision can do a lot, but it can't come close to doing it all. The book also tells a story. It's more than the votes of justices. It's the votes of individual people. It's elections. That's how we do transformative law in the United States. It shouldn't be through the courts. It's through elections. It also tells a story about how one person can make a difference. In this case, several one people made a big difference. Joe Mendelson certainly did. John Paul Stevens certainly did. And Jim Milkey did. And the team of people behind Milkey who wrote the briefs in those cases along with him. There are a lot of lessons for the book. I'm delighted to answer your questions now momentarily, but I want to mention one thing before I do, and that is next Monday, this coming Monday, February 28th, the Supreme Court is going to be hearing the next big climate change case. The question involving the validity of President Trump's repeal of one of the signature programs of the Obama administration for climate change, that was the Clean Power Plan. The court will hear that this Monday, February 28th, a case that I talked about at length, and my students did in the class I taught at Utah. And of course, it's going to take a different framing than in Massachusetts with CPA in this case. Why? It's a different court, a very different court than in November 29th, 2006. You can look at just one obvious fact. How many justices are left from Massachusetts versus EPA? 1 from the majority, Justice Breyer. 3 from the dissent, Chief Justice Roberts, Justice Thomas, and Justice Alito. Look at the other justices. It's pretty clear where the handwriting is, especially if you look at the COVID decisions the court decided just about a month or so ago. So the respondents, the Biden administration, they're framing this case very differently to try to figure out a way that they might come out at the very least with a soft landing. And those challenging and supporting the Trump repeal, they're swinging for the fences. Why? Because they think they now have a very sympathetic court. Thanks very much. I look forward to taking your questions and talking to Bob.
Richard, thank you very much for that very illuminating presentation. Tremendous insight into both the workings of the Supreme Court, the art of oral advocacy, the art of framing issues when one goes to court, and reminding us that there's life after the court decision, and that is often as important or more important than the decision itself as to the ultimate outcome, as we still wrestle with the climate issue today, not to mention the desegregation integration issue of Brown. We've got a few questions in the Q&A, and let me invite our audience to take advantage of the Q&A function at the bottom of the screen and send questions our way. Let me start. You highlighted Justice Kennedy's role in the Massachusetts versus EPA decision. One question is what ultimately caused Kennedy to shift, or perhaps maybe we should say stay on board, going through, what, 8 different drafts of the Stevens opinion?
Yeah. So I think it was a couple things. One of the threshold issues in the case, which I didn't have time to talk about now, but which is in the book, and those who read the opinion, was whether or not the environmental plaintiffs in this case in the states had what's called Article 3 standing or not, whether they had alleged sufficient injury, causation, reversibility to satisfy the court's pretty demanding Article 3 test to have standing to bring a case at all in the court. And Justice Kennedy had been on both sides of that issue in the past, sometimes with Scalia and sometimes not with Scalia. And what Stevens had to do was, one, qualify his opinion a little bit. I'll tell you exactly how he did it. And the other was cite Kennedy all over the place. If you read Justice Stevens' opinion for the court on standing, it's a group hug of Justice Kennedy. Anything that Kennedy wrote, block quote. As Justice Kennedy, it almost like reads like, as Justice Kennedy intelligently and eloquently put it, I couldn't put it any better. It's like one quote after Kennedy after another quote after Kennedy. But the real thing he did was this. He knew, because Kennedy made it clear, that Kennedy had a particular sensitivity to states and the ability of states as sovereigns to be plaintiffs in cases. And to get Kennedy's vote, Stevens wrote language saying that states get special solicitude in standing in climate cases. And that's how he got Kennedy's vote on that one. How he got Kennedy's vote in other parts of the opinion was by emphasizing how much discretion EPA would have on remand to do what it needed to do. Those are the parts that he wrote a lot of changes. At one point, so much discretion that's what made Souter clearly nervous, because he thought EPA had acted really irresponsibly in this case. So he wanted to chide EPA more. But to keep Kennedy's vote, Souter withdrew his thunder, and Stevens wrote it in a more sort of mild way.
Fascinating. I've noticed myself that Justice Kennedy, over the years, in the realm of property seem to be sensitive to environmental concerns. Often voting, if you will, with the more conservative justices, but writing separately to emphasize that there are environmental implications. I've often wondered if that's connected to his background in California, where he may well have been exposed to environmental concerns much more so than others might have been.
I agree. If you live in Cal, I think it very much had to do with his own life experience, and it affects all the justices that way. I mean, he knew that land is not land. That land can be fragile. It can erode. There can be earthquakes. There can be floods. There can be wildfires. The most famous case, of course, you know about Bob, where Kennedy basically parted from Scalia on that ground was the Lucas v. South Carolina Coastal Council case, deciding in, I think, June 25th, 1992. And that's where Kennedy said, no. Government can do a lot of regulation of land, much more than the common law nuisance can do. And that's because Kennedy understood. And I think it was his California experience which taught him that.
Yeah, he would have been exposed, among other things, to coastal zoning, and the list goes on. Well, you've got a couple questions basically asking about your prognostication on the West Virginia case. One asks, any chance the court will dismiss it as improvidently granted? And a second one asks, takes a pessimistic view. If it goes the way many think it will, given the court composition, do you think there's hope for a narrow holding, or should we prepare to see a massive shift in government regulatory power?
Right. So here's how I think about this case. Those are both great questions. And that's the question. There's no question here that as a practical matter, the petitioners who challenge the DC Circuit and validate the Trump repeal, they are going to win this case. It's just a question of how soft the landing is or how hard the landing is for the EPA. The best landing possible was posed by the first question, and that is the court dismisses the writ as improvidently granted. And the court could do that. But the reason why that's not normally that'd be a complete victory for the respondents. In this case, it's a victory at a price. The reason why the court would dismiss the writ is respondents have said, Clean Power Plan, forget about it. Clean Power Plan, it's dead and buried. Clean Power Plan, we're not going back to it. The Biden administration knows there's no way the Clean Power Plan, which many of the same people fought tooth and nail for during the Obama administration, with their signature program, they look at the court, they count to 6, and they knew they can't win that. So to try to get the court to dismiss the writ as improvidently granted and not case the case at all, they announced to the court in their briefings that the Clean Power Plan is gone. They asked the DC Circuit to stay their own mandate, which would have revived the Clean Power Plan, because they knew that would make it bait, low-hanging meat, raw meat for the conservatives. They've done everything they could to convince the court not to take the case. They're not doing everything they can to get the court to dismiss the writ. I think, even though the court took it anyway, the justices take things at the cert stage. They haven't thought about it as thoroughly as they do on the merits right now. I'd say there's about a 15 to 20% chance the court might dismiss the writ as improvidently granted. That is clearly the right result here. There really is no case left here. But I think there's about a 20, maybe 25% chance the court will do it. The Clean Power Plan will be gone, but the Biden administration can do it without the Clean Power Plan, which is what we're planning to do anyway. We'll know whether the softest landing is happening within the first 8 minutes of argument. Because when petitioners stand up there, if the Chief Justice and someone like Kavanaugh don't give them a hard time on Article 3 justiciability, they're not interested. It makes no difference if, Breyer, Kagan, and Sotomayor give them a hard time. We know where they think. So the question will be whether the conservative justices who normally care about Article 3 there, if they don't do that, if they do it, they may well dismiss the writ. If they don't do it, then the question is how hard the landing is going to be. And that goes to your second question. And that is whether or not it will be a narrow ruling or a broad ruling. And the narrower it is, the more that EPA will have on remand discretion to do a whole bunch of good things, I think, what I view as good things for climate regulation. The narrowest ruling, I'll give you the narrowest ruling possible, and then a much harder one, and then the hardest ruling of all. The narrowest one is the court will say the plain meaning of the statute just doesn't support going outside. We call outside the fence line of the Clean Power Plan. If they do that, EPA goes back. They can't base an emission limitation on what we call outside the fence line power plant regulation, but they can do a very demanding regulation inside the fence line, and all the state industry will comply with it with generation shifting outside the fence line. So that will be a sort of medium landing, narrow ruling. The harder landing is if the court instead says, under the major questions doctrine, the question about whether or not EPA can regulate in this kind of broad way is so big that they can only do it if Congress has given them specific language in the statute showing that Congress contemplated EPA doing this kind of thing we call it generation shifting as a shorthand for the time we have. If the court says EPA can only do it with specific congressional statements like that, that's a huge loss. Why? Because the AIR Act and all the environmental statutes are written like most statutes since the New Deal, based on giving the agencies broad, capacious language and authority. And then they get to fill the details based upon their technological expertise, their scientific expertise, their economic. The Congress can't anticipate that. If it turns out agency can do that only if Congress writes it in, that means most of the existing delegation of authority are not good enough. And good luck with trying to get Congress to pass a new law with specific language. When was the last time Congress passed a major environmental law? The Clean Air Act, 1990. The Water Act, 87. Why? Congressional paralysis. So that would be that'll have a devastating impact. The hardest landing of all, though, and some of the briefs in this case are asking for it, especially the amicus briefs. And John Eastman of the Insurrection Memo fame filed an amicus brief in this case. Some of the most extreme amicus briefs say it violates the non-delegation doctrine, even if Congress gives specific criteria for the agency. They can't do that. Congress can't, specific criteria or not, can't delegate big questions to agencies. Well, agencies can't possibly operate in that system. So we'll have to see what the court's willing to do and how far they're willing to go. It's a very aggressive court. If they're true to conservative principles, they'll dismiss the writ as improperly granted. There's no case left. If they really want to be muscular, the question is how far they go narrow, hard, or hardest.
Thank you for that in-depth
sorry about the length.
No. I think it's very helpful for people to understand that, including the implications for the non-delegation doctrine that you brought up there at the end. Whether we may see sort of a modification of that or a revival of it. We'll see in this matter. You've got an interesting question that has some Utah implications.
Good.
The question asks for your thoughts on how a state challenge to President Biden's relatively recent proclamation on our two national monuments, the Grand Staircase Escalante National Monument and the Bears Ears National Monument, might play out before the current Supreme Court. And I might add to that, taking into account the separate short opinion that Chief Justice Roberts appended to the decision not to hear the, the CMAP's monument case.
Yeah, the Massachusetts lobsterman case. Now, it's really a fascinating legal issue, right? As you know, and people in Utah know better than those of us out east. Presidents over the past several decades have been pretty expansive in their use of the Antiquities Act to designate very large areas of public land for preservation purposes. And Utah has often been an object of those presidential designations. Both President Clinton did so, and President Obama did so with major efforts to preserve under the statute this. The Trump administration basically very sharply narrowed those designations. And the fascinating legal issue raised is, can you do that? Can one president undo what another president did? And what's fascinating is these things have existed for more than 100 years, and the issue has really almost never come up before. There's a little precedent there. There's an attorney general opinion out there, but there's really no settled law whether one president can reduce. And there's a non-trivial argument that they can't reduce, which would be kind of odd because you wouldn't think that one president can do something permanently. On the other hand, it's not clear that the next president can do it. The courts never got to resolve that issue during the Trump administration. The litigation is all over the place. There are no rulings anywhere on it. And now, of course, the Biden administration is rolling back the rollbacks, which is now going to raise another question. So we're going to have a double, it's like a lawyer's dream and a law school final exam hypothetical about whether they can do it or undo it. But the thing you mentioned at the end, that's what's really interesting. The Supreme Court really hasn't weighed on this ever. And Roberts, the chief, in a recent dissent, not a dissent, excuse me, a completely unnecessary, gratuitous statement accompanying dissent of denial of cert. He said, I'm not so sure you can have these really big designations. He didn't say you couldn't, but there's language in the Antiquities Act which suggests it should be as small as possible. And he suggested there might be an area of judicial review to question how broadly they're done. That's not happened before. The language is there, been there a long time. We have a very textual court these days. It was certainly a shot across the bow. It was a shot across the bow to the Biden administration, and it was an invitation to all those people who don't like those broad designations, that there may be at least one vote up there receptive to them. And if that one vote is the Chief Justice, who these days is considered the most moderate of the 6 conservative, that's a pretty enticing vote. So I think it's very much sort of at issue now, much more than it was a few years ago, with that single statement by the chief.
To build on that, I'm just curious, based on your experience and observation, when you have a past practice that you alluded to of presidents, increasingly increasing the size of national monuments to get them up to, where they're now sometimes a million plus acres in size. Is that a factor, that this practice has gone on unchallenged with congressional acquiescence? Does that help to make the argument that the president has the authority with the conservative members of the Supreme Court?
Well, you add a little caveat there at the end. With the conservative justices, maybe not. It certainly is historically very, very influential on justices, especially in the public lands area, where the executive branch is considered to have much broader discretionary authority than in other kinds of authority under the Constitution. So historically, there's no question that kind of settled practice, unquestioned by Congress, would be very weighty. In fact, in one of the early exercises of that kind of authority, the Midwest oil case, in the turn of the 20th century, was one where there was really no authority anywhere you could find for President Taft's decision to basically stop allowing oil and gas leasing on public lands, and he did it, and the court embraced it under the idea of property clause power, and that the presidents have been doing that sort of thing without any statutory. They've done it for a long time, and Congress hadn't complained. So that has worked historically, that argument. But that's why your final words, Bob, with the court conservative justices. This is a group which is different. They took this West Virginia case when there was no reason to take it. This is a very aggressive activist court. It's also a court which is very into text. And they're going to look at the text of the Antiquities Act. And they're going to look at that language. I'm not as persuaded as I might want to be that they're going to think the fact that it's been past practice, the courts haven't objected as the equivalent of judicial precedent. And that's what makes this thing very much riskier than it once was, and something which I'm sure the Biden administration is taking very seriously and thinking about exercising the Antiquities Act right now.
Well, thanks for those observations. So textualism continues to carry the day.
Yeah. Well, even
more so than precedent. Let me ask that in those terms.
Well, here's what's interesting. if, like Massachusetts versus EPA, the court decided that greenhouse gases are air pollutants by a 5-4 vote, I have no doubt if the current court were to hear that issue ab initio, they would come out the other way. I also have very little doubt they won't overrule that part of Massachusetts versus EPA. And that's because the court historically does not overrule past decisions involving statutory construction. They overrule past decisions based on constitutional law because there's no other option. But they don't do it on statutory construction. I don't think they'll make a difference here. If there was a past Supreme Court opinion which had ruled on the language in the Antiquities Act, and it had been in favor of expansive is okay, I don't think the court necessarily overrule that. But we don't have that direct precedent on point. So it's a combination of textualism without a Supreme Court precedent on point. Because normally Supreme Court precedent on point on statutory construction, they figure it's Congress's job to correct their mistakes, not their job to do it. It's the absence of a clear case on point, which makes me nervous.
Gotcha. Yeah, very helpful to draw those distinctions, I think, for all of us to understand the difference between their constitutional rulings, their statutory rulings, and their perception of the role of Congress in this area of drafting statutes and revising them accordingly. You've got a lengthy question, I think goes to the question of does the court risk its own reputation by taking up a case like West Virginia? And the Sackett case is mentioned. If you're familiar with that, you might elaborate there. So impatiently and not letting the other branches do their work first. The other branches of government do their work first.
Yeah, I think they do risk their reputation. They look. I mean, a conservative court is supposed to not be activist. A conservative court is supposed to be more passive. A conservative court is supposed to not be second guessing Congress and second guessing the executive branch. Is supposed to be deferential. There's no small irony here that the original sort of mantra of the conservative judges and justices in the 1970s was no judicial activism. And now we have a very muscular, active court. So I do think they tend to undermine their credibility here. I wish I could say the environmental cases, though, they are first order for me. They're what I think and care about deeply, and I expect, Bob, you do as well. Like the Sackett case, we say didn't have to grant that case. EPA hasn't yet even put out a new rule. It's quite clear they're going to put out a new rule in this area. So it was really premature for the court to take that case as well. I don't know if the general public pays attention to that. I think the general public pays attention to things like Roe v. Wade, Second Amendment. I think if the court gets way ahead of the public on those issues in a way which makes it look them like they are second-guessing the ability of democratically elected legislatures to reach certain kinds of decisions, especially on things like the Second Amendment. If they do that, or they look like they're overruling past precedent, which seems to have settled over time, I think that's more likely to have that institutional reputation. I mean, Justice Sotomayor, stated pretty boldly. She said stench. Whether or not that's accurate, I don't think the general public view the environmental cases the way they could. I think that's too bad. Climate change is probably one of the world's and countries' biggest problems. Any delay in addressing that issue, risks enormous catastrophic and irreversible results. Other mistakes we can undo over time. That one we probably can't undo. So I hope the public pays attention to these cases. And I hope the court pays attention to the public paying attention to cases, and it moves them to be narrower rather than broader here. But I'm not as optimistic as I would like to be on that one.
Well, I'm not sure that's an upbeat note to leave us on.
Here's where I'll be more upbeat then.
Okay, good.
One is we've still won some cases with this court. There was a big Clean Water Act case. I say we, meaning people sort of favoring strong environmental protection. A big Clean Water Act case decided out of Hawaii about a year and a half ago. The court clearly took that case to rule against the environmental groups, the Hawaii Wildlife Federation, and they ruled in their favor 6-3 in a very expansive reading of the Clean Water Act. The justices are often quick at the trigger decide to hear cases, but sometimes they actually, when they see the merits, they play it straight. They played it straight there. The other thing I would mention is even worst case Clean Power Plan, the West Virginia case, Section 7411D of the Clean Air Act is not the only game in town. The marketplace by itself is ditching the coal industry and coal-fired power plants. They can't compete in the marketplace with wind, with solar, with hydroelectric, or with natural gas. They can't compete, and they have actually gone down more in emissions than even the Clean Power Plan wanted to do by 2030. They did it by 2019 because of the marketplace. And EPA has lots of power and lots of statutes, the Clean Water Act, the Resource Conservation and Recovery Act, Section 112 of the Air Act, to make the coal-fired power plants actually absorb the true cost of their pollution. If they do that, it will accelerate even more a decrease in what is the single, I think, most damaging source of greenhouse gas emissions in the United States, and very unnecessary, and that's the electric power industry. So I still remain optimistic. I'd like to see some other new members of Congress, though, who are willing to actually pass legislation rather than just be in litigation.
Right. Well, yeah, I agree. It would certainly make sense if Congress would step up and do something in this area. It's past time to be moving forward here. Well, with that, let me thank you once again for taking the time to share your book with us, to give us an inside view of the Supreme Court, to share your observations on environmental law and where we may be headed, to remind us that there is the court, but there's also the realm of politics and the realm of the marketplace in terms of addressing our environmental problems. With that, let me remind our audience of the upcoming Stegner Center Symposium, March 17th and 18th, the Colorado River Compact, Navigating the Future. I'd also be remiss if I didn't note that the King's English Bookshop joined us today as our virtual bookseller, and Richard's book is available through the King's English Bookshop. So take time to check in with them. And with that, let me thank everyone again for joining us. Richard, once more, thank you. Enjoy your 60-degree day in Massachusetts. We'll enjoy our 20-degree day here in Utah.
All right. Thanks a lot, Bob. It was a real pleasure.
Take care.